Welcome to Sound Unlimited for all things newsy, juicy, sporty, tasty, and more.
The MEYIWA case resumed today with an application by the defense for a request for accused number 3 to do a dental examination. Accused number 3, Mthobisi Mncube, has been granted permission to undergo a dental examination in order to disprove the state's assertion that he had a gold tooth. His legal representative, Advocate Charles Mncube, argued that it would be unfair for him and his client to cross-examine cell phone data analyst Sergeant Moses Mabasa before they were given time to prepare their defense against the new evidence that the state presented. He said the state shocked them with the new evidence that they were not made aware of 23 months into the trial. The evidence in question is of photographs that allegedly show accused number 3 with a gold tooth. Mncube has opted to go to an independent dental practitioner as opposed to the one offered by the state. He said he did not trust the state. Let's listen to the arguments for and against and the judge's ruling.
If his evidence appears to the court essential to the just decision of the case, that is what 167 says. 186 says, if the evidence of such witness appears to the court essential to the just decision of the case. The operative phrase here is just decision of the case. Now, in amplification of what is being said about this provision, this is what we're submitting. That although the two provisions of the Criminal Procedure Act do not deal with affording the applicant a reasonable opportunity to prepare for his defense in order to challenge the state's case against him, the evidence that he requested the court to allow him the opportunity to amass is essential to the just decision of the case. And this is exactly what Section 167 and Section 86 says. This deals with the justness of the decision of the court in respect of the case. Now we are submitting, my Lord, that the just decision is one that is based on the ethos of the Constitution. It is one that is arrived at on the principle of the rule of law. It is one that is fair in terms of Section 35(3) of the Constitution. And all these factors are embodiments of a fair trial. My Lord, we're not requesting something fancy, something trivial, something unheard of. All that we're requesting is that we be afforded an opportunity that we should go and prepare for our defense. We be afforded the opportunity to have adequate facilities to prepare our defense, and then from there we proceed with the cross-examination of Warrant Officer Mabasa. And I remember when we were growing up, there in the farms, in the Eastern Transvaal, there was this Afrikaner-speaking person who always used to say, "Ek vra nie te veel van die wêreld nie. Net as steekie brood in 'n botteltjie van branderij sal maak." That is exactly what this accused person, what Mr. Mncube is asking for. He doesn't request much of the world. He does not want the world in his hand. He does not request for gold. He does not request for petals or diamond. All that he is requesting for is that he be afforded the right that the Constitution confers on him as an accused person in terms of Section 35(3), that he be afforded the opportunity and facilities to go and prepare for his defense. Now, we are further submitting, my Lord, that this information, which would have been as a result of his preparedness, would bring some kind of objective evidence to the court. that is not based on speculative hypothesis. The nature of the evidence that he seeks to produce to court during the cross-examination of Warrant Officer Mabaso carries a significant weight in assisting the court to come to a just decision of the case, as this is called for in Section 167 and in Section 186, the just decision of the court, without which, my lord, there will be doubt as to whether the decision that the court would have arrived at without affording Mr. Mncube this opportunity to go and prepare for his defense would be just. Now, he does not do this in vacuum, my lord. He definitely does not do this in vacuum. He is drawing a parallel or a comparison or an analogy between what is happening to him now and the case of accused number 2, that is Mr. Mthobisi. And I'm sorry to even mention his name in this case, but it is only fair that that parallel should be done. Now, the court will remember that there were also allegations of a similar nature that were raised against Mr. Mthobisi, who is accused number 2 in this matter at the very beginning of the trial. And if my memory serves me well, he got referred to for dental assessment. The result of his assessment were presented to court as evidence through Dr. Tokwe. Thank you, Mr. Ramsupi. Through Dr. Tokwe. And as a result of the report that was placed before court, Mr. Mthobisi was able to challenge the state's case on that aspect of the evidence because he had all the information at his disposal and having had been accorded sufficient time to prepare for his defense in this regard. It is thus inconceivable that the applicant can be denied a similar opportunity. Denying him that opportunity will be contrary to the spirit of the Constitution and will violate Section 9 of the Constitution of the Republic of South Africa, Act number 108 of 1996, which states as follows. Now, Section 9 of the Constitution deals with equality. And Section 9.1 of the Constitution says, everyone is equal before the law and has the right to equal protection and benefit of the law. Everyone is equal before the law and has the right to equal protection of the law. Again, my lord, I went through the Constitution. I could not find a clause that says everyone is equal before the law, but some are more equal than others. It really can be that Mr. Mthobisi, in the preparation of his case and the cross-examination and in the cross-examination of witnesses who had come to testify on whether or not he had a golden teeth at the time at which this offense was allegedly committed, had an opportunity to prepare for that defense. And the same opportunity does not get afforded to accused number 3, who is an applicant in this matter, who gets confronted with this new evidence 23 months after the commencement of the trial, who gets confronted with this evidence that the state had in its possession for 5 years. I'm talking about the prosecution now. That the state has been in possession of this information for almost 10 years. I'm now referring to the police. That will not only be fair, my lord. Accused number 3 will be denied dignity not only in this trial, but in heaven and earth. Will not be accorded to the proper dignity. Now, I've said, my lord, that our application is based on certain pillars. That was just but what the Constitution was saying. Now, we further submit that The approach to a fair trial right was enunciated as follows by the Constitutional Court in the case of State versus Japai. Now, the citation of that case is a case that was heard in, or the citation is 2005, volume 1, SACR, page 215. It's a Constitutional Court decision, and the judgment was delivered on the 18th of February 2005. My memory serves me well. I think it was delivered by Judge van der Westhuizen, and let me just confirm that now. Yeah, I think it was the Honorable Judge van der Westhuizen, as he then was at the Constitutional Court. Now, this is what he said on paragraph 26 of his judgment. Now, he says, Section 35(3) of the Constitution states that every accused person has a right to a fair trial. The basic requirement that trial must be fair is central to any civilized criminal justice system. It is essential in a society which recognizes the right to human dignity and to the freedom and security of the person, and is based on the values such as human rights and freedoms, the rule of law, democracy, and openness. The importance of universality of the right to a fair trial is evident from the fact that it is recognized in key international human rights instruments. I'll come back to the key international human rights instrument. Now, I am wondering, my Lord, whether I need to amplify what what the Honorable Judge van der Westhuizen says in paragraph 26. Because if I were to attempt to do that, I would basically spoil what he eloquently so professed. Let it stand as is. Now,
sorry, is it not Ackerman?
No. Ackerman, I think, was involved in case versus Tsukuta. Yes. Now, at the time when we were also brainstorming this possible application, the court remarked that if needs be, the applicant can also refer to the Canadian laws and all those international instruments, my Lord. Indeed, what Judge van der Westhuizen, what's the reason of van der Westhuizen? I think it's van der Westhuizen, but I'll confirm that, my Lord. Says in his very last paragraph of the extract that I've referred to the court to, says the importance and universality of the right to a fair trial is evident from the fact that it is recognized in key international human rights instruments. And indeed, Article 14 of the International Covenant on Civil and Political Rights states as follows: in the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality. In full equality. Number A, to be informed promptly and in detail, in a language which he understands, of the nature and cause of the charge against him. Number B, to have adequate time and facilities for the preparation of his defense, and to communicate with counsel of his own choice. I think I need to emphasize what number B says. To have adequate time and facilities for the preparation of his defense, and to communicate with counsel of his own choice. And number C says, to be tried without delay. Now, being confronted with new evidence 23 months after the trial had begun, exclusively new evidence, that cannot be said that that's been a trial without a delay. because it is that after 23 months, after the commencement of the trial, that the state then jumps up and says, no, but we've got new evidence against these accused. And this position, my lord, may I respectfully submit, should be differentiated from a position where the state comes and says, we were not aware, we did not have this information, we only got this information in the course of the trial. Because I know from a prosecution background that when a case is proceeding, the state does not stop to investigate up until the trial is concluded. But this is not a position in this case. The state in this case had this information at their disposal even at the time when the accused were called upon to come and plead. As I've said, the investigating team had this information at their disposal for almost 10 years. And as I've said, the prosecution had been in possession of this information for more than 5 years. Why has it not been made available to the defense at that moment in time? It remains a mystery. But be that as it may, my lord, it is our submission that the making available of this information at this hour of reckoning simply constitutes a justice delay, which is a justice denied. The state can therefore not come back and say, yeah, no, but if this accused person would be entitled to a further postponement or be afforded the opportunity to go and prepare his defense for this, for come and cross-examine a warrant officer, Mabaso, that is going to delay the state. That will be a sin for the state to do that, my lord. That will be unheard of. That will be a gross irregularity of a submission, because this is a bed of roses that has been made by them. I've got no reason not to say that it's a bed that they made themselves and they've got to lie on it. But Article 10 of the Universal Declaration of Human Rights Article 10 of the Universal Declaration of Human Rights states as follows, that everyone is entitled in full equality to a fair and a public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charge against him. Now, the operative word in that Article 10 on the Universal Declaration of Human Rights, it's the word fair, that everyone is entitled to a full equality to a fair and a public hearing. Will it be fair for the accused to be afforded an opportunity and facilities to go and prepare for his defense in order to come and challenge the state's evidence on an evidence that it gets confronted with, which is new, 23 months after the commencement of the trial? Will that be fair? If anybody will say, my lord, that would not be fair, then I would be allowed to I'm going to request to confront that person and say to him, they really don't understand what the meaning of fairness in legal context is. Because on a number of occasions, this court has been referred to an authority. I just forgot that authority. It's just coming to my mind now. Fairness must not only be fairness at the instance of the accused person, but it must also be fairness at the instance of those that are being affected by the crime, the society.
State versus King.
That's King, my lord, yes. Those are the ethos of fairness. Those are the ethos of fairness. accused, in other words, accused person must appreciate that he is not the only beneficiary of fairness in a trial as it proceeds, but the state as well must also acknowledge, as it represents the 64 million of the South African population, the 64 million people in South Africa that are looking at him. The state must also acknowledge that fairness is not only about that 64 million, it's also about the accused person as well, particularly if his reasons for request of fairness are well grounded, such as a method such as this one. Now, I'm proceeding with the international instruments. Now, they are referring to this as article in South Africa. We would have referred to this as section, but they choose to use the word article. And then Article 6 of the European Covenant for the Protection of Human Rights states as follows: in the determination of his civil rights and obligations, or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Again, that phrase, fair, fairness at the hearing of a criminal matter, crops up again, my lords. I need not amplify this. It is exactly what is stated here. That has been the European Covenant for the Protection of Human Rights. Now, in our continent, it does not mean that there's no recognition of fairness in a criminal matter. And this is what the African Charter of Human and People's Rights says on Article 7. It's a very long article, but with the permission of the court, let me read it. Now, it says, Article 7, sub-article 1, every individual shall have the right to have his cause heard. His cause heard. This comprises the right to an appeal to a competent national organs against acts of violating his fundamental rights and recognized and as recognized and guaranteed by conventions, laws, regulations, and customs in force. The right to be presumed innocent until proved guilty by a competent court or tribunal. The right to defense, including the right to be defended by counsel of his choice. The right to be tried within a reasonable time by an impartial court or tribunal. No one, that's now sub-article 2, no one may be condemned for an act or omission which did not constitute a legally punishable offense at the time it was committed. No penalty may be inflicted for an offense for which no provision was made at the time that it was committed. Punishment is personal and can be imposed only on the offender. Now, Article 7, sub-article 1, paragraph C says the right to defense, including the right to be defended by counsel of his own choice. That might sound a little bit irrelevant in this application, my lords. Yes. This article simply says accused person has got the right to defend himself. Now, how does an accused person defend himself when he's not afforded the opportunity to prepare, when he's not afforded the opportunity and facilities to prepare for his defense in attaining what is universally known as a fair right to a trial? That will be virtually impossible. As I've said initially, that if such were to happen, then accused person would have been denied the necessary dignity and respect in the trial in which he is involved, my lord. Now, in State versus Zukuta and others, I think this is a judgment of the Honorable Judge Ackerman. It's a judgment it's a very, the citation there, it's 2011 Butterworth Criminal Law Report, page 1252, Constitutional Court. And it was penned, or it was given on the 27th of September 2000. Now, this is what the court had to say in Zukuta. Now, in paragraph 9, the court said, as was laid by this court in Zuma's case is also a constitutional court judgment.
Yes, it is.
Yes, my lord. And it does not refer to the former state president of the country, Mr. Jacob Kedlayi Zuma. It refers to another Zuma. An accused rights to a fair trial under Section 35(3) of the Constitution is a comprehensive and embraces a concept of substantive fairness, which is not to be equated with what might have passed muster in our criminal courts before the Constitution came to force. These comprehensive rights are specified in paragraph A to O of subsection 3 of section 35 of the Constitution. The words which include the right preceding this listing indicate that such specification is not exhaustive of what a right to a fair trial comprises. It also does not warrant the conclusion that the right to a fair trial consists merely of a number of discrete sub-rights, some of which have been specified in the subsection and others not. Now, the right to a fair trial is a comprehensive and integrated right, the content of which will be established on a case-by-case basis as our constitutional jurisprudence develops on section 35(3) of the Constitution. Now, at paragraph 11, the court continued to say the following. At the heart of a right to a fair criminal trial and what infuses its purpose is for justice to be done and also be seen to be done. But the concept of justice itself is a broad and a protean concept. In considering what lies at the heart of a fair trial in the field of criminal justice, one should bear in mind that dignity, freedom, and equality are the fundamental values of our Constitution. An important aim of that right to a fair trial is to ensure sufficiently that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. As I've said, my lords, initially, or in the course of my submission, I am wondering if I need to amplify this, because I am afraid that should I start to amplify this, I am going to spoil what the Honorable Judge of the Constitutional Court so eloquently proffered in this paragraph in his analysis of what a fair criminal trial is. I would rather not spoil it by trying to emphasize it, my lord. But now...
You don't want to quote Kentridge?
I'm coming, my lord.
Oh, I see.
Yes.
Okay.
Yes. I think the Honorable Judge Kentridge was involved in the Zuma case.
Yes.
Yes. Now, the court, as I've said initially, that it hinted that he's not aware of a specific procedure that would allow the court to deal with the situation which is the basis of this of this application. And this is my submission in that regard, my lord. Now, I'll come and deal with the provisions of Section 173 of the Constitution. We are saying in our heads of argument that, as we have mentioned in paragraph 20 of our heads of argument, the Criminal Procedure Act does not have a specific provision which deals with the matter under consideration. In dealing with this apparent lacuna, the court in the Tsagudza case stated the following at paragraph 10, and it said, it cannot be assumed that a fair trial, as required by Section 35(3), can only be achieved by one system of a criminal procedure. I think I need to repeat this. It cannot be assumed that a fair trial, as required by Section 35(3), can only be achieved by one system of criminal procedure. There may be more than one way of securing the various elements necessary for a fair trial, and provided the legislature devises a system which effectively secures such rights, it cannot be faulted merely because it settles for a system which departs from past procedures. The norm prescribed by Section 35(3) is a fair trial. The question to be determined in each case is whether the criminal procedure scheme or the relevant part thereof, devised by the legislature, whatever its form, conforms in substance to that norm. Now, again, my Lord, I do not wish to amplify what the court said in this Zuma case. I mean, in this Tsagudza case that I've just referred to the court to. This simply means that even if the Criminal Procedure Act does not make a provision for a specific procedure in on how circumstances such as this one should be dealt with, the courts are called upon, if that would not be a violation of the law, to implement or to see to it that the spirit of the Constitution is implemented or is given effect to, my Lord. Now, Section Section 173 of the Constitution states as follows: inherent power. The Constitutional Court, the Supreme Court of Appeal, and the High Courts of South Africa each has the inherent power to protect and regulate their own processes and to develop the common law, taking into account the interest of justice. Let me repeat this. Taking into account the interest of justice. In other words, the Constitution was well aware, or the Constitution drafters were well aware, that there may arise circumstances in the course of trials, whether in criminal trials or in civil trials, in arbitration matters, etc., 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 where the effect of the Constitution should be given effect to. However, because of lack of a specific procedure in dealing with that particular scenario, then the court might come and say, no, but there's no law that says we should do this. There's no law that we should do that. Then the drafters of the Constitution thought ahead and said, no, Mosi, the Constitutional Court, the Supreme Court of Appeal, and the High Court, let us give them inherent powers to regulate their own processes and to develop the common law. In other words, even if such procedure is not specifically stated in the subordinate legislation, that should not be a bar to them not to give effect to the spirit of the Constitution. They can simply invoke their inherent powers and say, no, in the interest of administration of justice, and in this case, in the interest of a fair trial in terms of Section 35(3), we are going to adopt this process for as long as nobody is prejudiced, for as long as nobody is going to cry foul of the process that we are going to implement. We are going to do this. That is the power. It's a power I wish I had, my Lord, as a person. Unfortunately, the Constitution doesn't really warrant that individual people should have these powers. These are all embracing powers, inherent powers. But they are not supposed to be utilized in a vacuum. They are supposed to be utilized in instances where the interest of justice demands. Now the question is, do interest of justice demand that accused number 3 be afforded the opportunity to go and prepare and the necessary facilities to go and prepare his defense on the new evidence that has been introduced by the state? 23 months after the trial has commenced, when the state had this information for 10 years in their possession, when the state has this information for 5 years in their possession, should the court really invoke these powers in order to see to it that Mr. Mncube is accorded a fair trial? I am looking forward with keen interest to receiving an unfavorable answer to that question. Thank you.
Thanks. Ramsipin?
I'm not done, my lord.
You're done?
No.
Oh, okay, fine.
Thank you, my lord.
I thought you said when you say thank you, it means you're finished.
No, I'm saying I am looking forward to receiving an unfavorable response to the answer that I've asked as a solilog. And I was saying thank you to that, my lord.
Oh, I see.
Now, we further amplifying what has just been mentioned by the inherent power as follows, my lord. The provision of this section ensure that when the courts, now which section? Section 173. Ensure that when the courts mentioned therein are called upon to give effect to the spirit of the clauses of the Constitution, are not limited in their duties to do so for want of a standing procedure in circumstances where one does not exist. Now, the Constitution is the supreme authority that is superseded by none. The preamble to our Constitution states as follows, my lord, that the Constitution is adopted as the supreme law of the Republic so as to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental human rights. Does what Mr. Mncube requests this court to accord him not a fundamental human rights? I am also looking forward to receiving an unfavorable response to this question, my lord.
Sorry. But I know the clauses.
Yes.
You know what strikes me, because I think aloud.
Yes, my lord.
I thought you'd say South Africa belongs to all those who live in it. Is that not how it starts, the preamble? Okay, never mind.
I've got a constitution here, my lord.
No, you said the preamble.
Yes.
Yeah, does it say that?
Let me say part of the preamble that is relevant to the case that I'm dealing with here, my lord. I'm looking at a clause that says South Africa belongs to all those who live in it. It does not say, it says we, the people of South Africa,
We declare?
recognize the injustices of the past, honor those who suffered for justice and freedom in our land, respect those who have, let me wear my spectacles.
There's a doctor. Where's the doctor? He knows it by heart.
Thank you, my lord. I've just worn my spectacles now. It says, respect those who have worked to build and develop our country. Those who have worked to build and develop our country, and believe that South Africa belongs to all those who live in it, united in our diversity. We, therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic of South Africa. The court just asked me whether it says all those who belong to believe that South Africa belongs to all those who live in it. Yes, it says South Africa belongs to all those who live in it lawfully.
Yeah, okay.
Yes.
Even unlawful.
Yes, Mara. It does not promote illegalities or unlawfulness. It simply says all those who live in South Africa lawfully.
Fine.
I may not get into the terrain, my lord, because that's not the purpose of this explanation. Now, my lord, it says that the Constitution is adopted as a supreme law of the Republic so as to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which the government is based on the will of the people and every citizen is equally protected by the law. Mr. Mncube, Franite Fiel van die Wêreld, he does not request a lot of this world. He simply says to the court, can I please be afforded the opportunity and the necessary amenities, which are facilities, to go and prepare my defense, even before I start to cross-examine Mr. Mabaso. Because the evidence that Mr. Mabaso just came up with was a shocker to me. I have not been expecting that I'll be confronted with this evidence 23 months after the trial. He does not ask too much. He simply requests that, my lord. Now, Section 2 of the Constitution states as follows: the supremacy of the Constitution. This Constitution is the supreme law of the land. Law or a conduct which is inconsistent with it is invalid, and the obligations imposed by the Constitution must be fulfilled. Now, Mr. Mncube is not standing there and saying, can you please hear me and hear me well? I am crying for the following, basing his pleas on nothing, simply basing his pleas on the Constitution of the Republic of South Africa. And Section 2 of the Constitution says that the obligations that are imposed by the Constitution must be fulfilled. Section 35(3) is a right that is imposed by the Constitution. Why should it not be imposed or fulfilled? Fulfilled, actually, that's the way that is used by the Constitution. Why can't it be fulfilled? Yet again, my lord, I will be waiting very keen for an unfavorable answer to this question. Now, we further submit, my lord, that an institution, including courts, will thus not be castigated merely because that system or the court are settling for that institution or the court are settling for a system which departs from past or standing procedures in its quest to see that justice is not only done, but is also seen to be done. Those who understand the phrase, justice being seen to be done, those who understand the phrase, justice being done and being seen to be done, would basically understand what it really means in the context of this case, my lord. Now, as we conclude, my lords, we are saying that the applicant in this matter does not request for something that is out of the ordinary. He simply implores this court to allow him to utilize his constitutionally guaranteed rights in the conduct of his defense during this trial. There is no harm which will be suffered by anyone in him being allowed to utilize the said rights. However, the opposite is detrimental, as was expounded in the Tsukutsa case, where the court held in paragraph 11 as follows: that an important aim of the right to a fair criminal trial is to ensure adequately that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and other interests of the accused. Now, we are saying, Maharaj, that on the conspectus of the merits of the case and on the basis of the above mentioned, being the Constitution, being the cases that the court has been referred to, it is respectfully submitted that the applicant has successfully made a case to have this request granted by the Honorable Court. I would further add, my Lord, that I think it's a point that I've already mentioned. I'm not even so sure.
You want costs?
No.
Okay.
No, my Lord. That I'm not so sure whether I've mentioned the fact that I have not even taken proper instruction from Mr. Mncube with regard to the cross-examination that I need to have to the accused. But if I've mentioned that, so far so good, my Lord. But finally, my Lord, if the Constitution was a human being, if the Constitution was a natural person as opposed to a juristic person, this is what the Constitution would have said, an open court. It would have said, dear Honorable Court, please do not be deterred or dissuaded from giving effect to the spirit of the provisions of the Constitution for a want of a specific procedure from the Criminal Procedure Act. The Constitution has empowered you in terms of Section 173 to protect and regulate your own processes if that is in the interest of administration of justice. And then the Constitution will close its case, will close its code. That will be our submission.
Okay. In State versus Sheikh 2007, ZACC on page 19, also reported 2008, volume 2 SA, page 208, Constitutional Court on paragraph 43, the court held that fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that accused rights should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it impracticable to conduct prosecution. See also Key versus Attorney General Key Provincial Division in another 1996, ZACC on page 25, also reported in 1996, volume 4 SA 187, it was the decision of the Constitutional Court, paragraph 13. Then paragraph 4 will deal with the legal position regarding the cross-examination of Sergeant Mamas. Paragraph 4.1, Section 166, subsection 1 of the Criminal Procedure Act creates the right for the accused to cross-examine any witness called on behalf of the prosecution at the criminal proceedings. Cross-examination is therefore one of the essential components of the adversarial system of procedure. The purpose of cross-examination is to elicit evidence favorable to the party cross-examining or to challenge the truth. Page 4, or accuracy of evidence given by the opposing party. Per the court in State versus Mncube, 2008, volume 1, South African Criminal Reports, and page 71 at paragraph 76G. Paragraph 5, the state deals with the explanation as to why the examination by the dentist is required for purposes of cross-examination. No reasons have been furnished as to why the examination by a state and a private dentist is necessary. It is difficult to determine whether the request is frivolous or not, or part of deliberate delaying tactic designed to secure the party concerned some unfair advantage over the opponent. No version has been put to Sergeant Mabaso as to whether the accused number 3 has had a gold tooth or not. Such a proposition should not depend on whether he has been examined by a dentist first. If accused number 3 disputes that photo in question depicts orthodontic work or gold tooth, he can put that proposition to Sergeant Mabaso. If he disputes Sergeant Mabaso's observations, he can put it to him that he is his observation is wrong and that he did not have a gold tooth at the time. Moreover, Sergeant Mabasa is not an identifying witness. He is merely testifying about his own observation on the photo he has downloaded and authenticated. Should the need arise, he can make a request to be dentally examined during his case to support his version that he will be placed on record. Should we get to that point? In State vs. Scott Crossley 2008, Volume 1, SACR, on page 223, the Supreme Court of Appeal on paragraph 26 cited a passage in Phipson Evidence 7th edition at page 460 to the effect that, as a rule, a party should put to a witness in turn so much of his own case as concerns that particular witness. Just to amplify that point, my lord, in criminal proceedings, the right to give and challenge evidence is a fundamental principle of a fair trial. It means that an accused have a right to present their own evidence and a right to question evidence. A right to present his own version of events through cross-examination. And that is our submission, my lord. Advocate Mncube can proceed to put questions to Sergeant Mabasa on the fact or on the strength that accused number 3 never had a gold tooth. And that fact falls within the personal knowledge of the person. He does not have to be assisted by a dentist to make up his mind. He can put it as a fact. And at a later stage, it can be supported by a dental examination. And right to challenge evidence or by putting questions will also assist to challenge the accuracy and reliability of evidence that is brought by Sergeant Mabasa. Sergeant Mabasa is testifying based on his observations. There is nothing stopping evidence to challenge Sergeant Mabasa regarding his observations. My lord, in this court, we had an instance where evidence, ballistic evidence of Colonel Mangen, put in abeyance for almost a year to enable the defense to secure a ballistic expert in order to rebut or to challenge his evidence, which is perfectly allowed. But in this instance, the accused person wants to be examined to challenge the evidence of Sergeant Mabasa, which the source of his observation. He looked at the photo and he placed on record what he has observed. It will have been a different request altogether, my lord, if accused number 3 wanted to employ the services of another analyst with the same qualification as Sergeant Mabasa to challenge whether the downloads and the photo that was flighted or beamed on the screen on the 12th of June 25 rather, is authentic or not. That would be different. But for the defense to request to determine the direction of the wind before they can make up their mind, my lord, we submit with the greatest of respect. That is not procedure, my lord. A version must be put before Mabasa, and Mabasa must be able to comment on that. The instructions that accused number 3 gave is not dependent on examination by the dentist. Now going back to the written head, in President of the Republic of South Africa, versus South African Rugby Football Union, 2000, Volume 1 SA. The Personal Code in paragraph 61 and 63, it was stated that the institution of cross-examination not only constitutes a right, it also imposes certain obligations. A general rule, it is essential when it is intended to suggest that a witness is not speaking the truth or on a particular point, to direct the witness' attention to fact by question put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity, whilst in the witness box, of giving any explanation to open to the witness and defending his or her character. If a point in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness testimony is accepted as correct. This rule was initiated by the House of Lords in Brown versus Dunn and has been adopted and consistently followed by our courts, end quote. And paragraph 63, the precise nature of the imputation should be made clear to the witness so that it can be made and destroyed, particularly where the imputation relies upon inferences to be drawn from other evidence in the proceedings. It should be made clear not only that the evidence is to be challenged, but also how it is challenged. This is so because the witness must be given an opportunity to deny the challenge, to call corroborative evidence, to qualify the evidence given by the witness or others, and to explain contradictions on what reliance is to be placed. Paragraph 6, the interest of justice. 6.1, it is respectfully submitted that it is not in the interest of justice to allow accused number 3 to cross-examine Sergeant Mabasa after the dental examination. The legal representative of accused number 3 and other counsels can cross-examine Sergeant Mabasa as they see fit, put the version of their clients. Sergeant Mabasa is an analyst. As a result, he must be challenged with the information in the XRY format, which cannot be tampered with, edited, or manipulated in any way, and by his observation of the photograph of accused number 3 depicting him with a gold tooth. Page 6.2, in R vs. Hepworth 1928 AD 265 at 277, you all know this case off by heart by now. The court held that criminal proceedings are not a game in which one side is entitled to play the benefit of any omission or mistake made by the other. The duty of a trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We submit, my lord, that justice would be served by not allowing the Sergeant Mabasa to be cross-examined only after accused 3 has been examined by both the state and private dentist. 6.3, in State vs. Sheikh and RCC, I've already cited this case. 2007 Constitutional Court decision, also reported 2008, Volume 2 SA, Constitutional Court. And the court held as follows: the applicant stresses that they place their reliance on the general right to a fair trial, which, as this court has dealt, extends beyond specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right to an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state, must instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and the horror of the crime. On emphasis for edit. In multi-choice property limited and others versus National Prosecuting Authority, and another 2014 ZAGPHPC 37, also reported 2014, Volume 2 All SA reports. decision that comes from this division. As Pemelambo, J.A. held that our constitutional court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. In this regard, the Constitutional Court in State v. Zukuda and others, and State v. Chilo, confirmed that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial, what infuses its purpose is for justice to be done and also sin to be done. B. In State v. Lamini, State v. Ladla, and others, State v. Joubert, State v. Itekat, 1999, Volume 9, SACR, page 51, Constitutional Court also reported 1999, Volume 4, SA, 623, 1999, Volume R, BC, LR, 708, page. Krikhala J described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and to all concerned. All emphasis. Paragraph 6.4. It is therefore respectfully submitted that the application by the accused number 3 be refused. As a copy, please.
Yeah, so few questions.
My apologies, let me just proceed. Furthermore, Mr. Ramos Sepile on his paragraph 2 or in the one of his written heads of arguments also made mention of section 37 subsection 3A of the Criminal Procedure Act, my lord, and we submit, my lord, that the section 37 subsection 3A is not applicable. It strictly refers to taking of fingerprints and bodily prints, and we request the court not to also consider that.
So this is submitting that the analogy of that case, the court of justice may consider it.
Indeed, so my lord. If then the court consider that by all means accused person can be taken for examination.
But that case,
Yes.
relates to a witness, is that so? Sorry, not a witness, an accused person.
Yes.
Who refuses that his fingerprints must be taken?
Indeed, so my
That's the
lord.
distinction. You see, he's using his own will, free and voluntarily. And he says, no, I won't let them take my fingerprints. I don't want them to be taken.
Yes.
Now the court is taxed to decide this, because the law actually makes provision for fingerprints to be taken using reasonable force. What section is it?
37.
Pardon?
Section 37.
37, my lord.
Section 37.
Yes, I'm saying the law empowers the court to instruct the court order, for instance. They take random offenders, fingerprints, using reasonable force.
That's so.
Why? This is not different from.
It is different from what we are dealing with at this
Is
stage.
that okay?
That's
Going fine.
Furthermore, my lord, Advocate Mncube during his address indicated that he does not know the aim of the evidence that the state tenders. However, Mr. Ramos Sepile answers him on paragraph 3 of his submissions, and he says the aim of recalling Sergeant Mabasa was to introduce photographs depicting accused number 3 with a gold tooth insertion. The allegation that one of the intruders at the Kumalo household on 26 October 2014 had a gold tooth. It is with this in mind that Mr. Mncube makes an application for his medical examination to rebut the allegation against him. So when did this evidence that one of the intruders had a go to, then we go back to the evidence, Exhibit G. And if I recall very well, the first counsel to introduce Exhibit J in this proceedings was Advocate Mncube, going through what Thabang Makiling said regarding one of the intruders. And then it was also said that one of the intruders had a gold tooth. That's how it started. And then you can pull the record, mate. Yes, that's how it started. And there's no way, even during cross-examination of Brigadier Gininda, where Advocate Mncube puts it to Brigadier Gininda that accused number 3 never ever had a gold tooth. Gininda was just asked to go through the photos, to identify, to give descriptions, and that we see on the proceedings of the 29th of November 2014. And I'll just read the passage. And this was what was Advocate Mncube saying. But having said that, let us go to Exhibit S. You take us through these photos. Those downloaded photos that you were taken by accused himself with dreadlocks, big eyes, with golden teeth. We can request the stage for us on so that the accused persons can also follow. Start with the first picture. That's how this issue started. And it was never disputed or Gininda being challenged on this fact that accused number 3 had a gold tooth. It's only now when I made an endeavor to lead such an evidence that accused number 3 wants to be examined by a dentist to assist him, my Lord, to proceed that we submit that cross-examination of the witness can proceed without him being sent for oral, for examination by a dentist. And the point is not one of procedure, but it's one of following the established rules of cross-examination.
Yeah, but then Mr. Mncube says he has not consulted his client. Am I correct? Let me continue, Mr. Mncube. You say, I have not been able to consult my client. I have not consulted my client.
That is correct. That's correct.
But Mele, just to also add on, Mr. Mncube also indicated the photos are in excess of 5,000 photos. I think he's mixing the photos. The 5,000 plus photos that are for accused number 2. With accused number 3, it was plus minus 700 photos. And then I submit my Lord before this court. These photos are voluminous, and it was only then when Advocate Mncube requested a postponement to prepare cross-examination on behalf of accused number 2, that the state as well as the investigating team were able to sit down, go through those photos one by one. It was not a very easy process, my Lord. It took some time for it to be. So it's not correct that we said with the evidence. The evidence was discovered to the defense. I think after the 1st of August 2023, after the evidence of Sergeant Mabasa, all the photos were given to the defense. And the defense are in possession. Even that specific photo that is a subject matter before this court.
I was thinking that on the 1st of August 2023, the photos were in existence already.
Yes. They were in existence, just that
where were they procurable?
My Lord, I remember during that period that we have to adjourn went to our offices, we sat down with Sergeant Mabasa, and then we went through those photos, and certain additional photos were also selected. And we further discovered the whole band USBs that Sergeant Mabasa copied and handed each and every defense cousin. And amongst the photos that we handed in is the photos that we introduced or last week through Sergeant Mabasa. So the photo has always been there.
Okay, fine. It's a misnomer, but the pertinent question is, if the state was not aware of this evidence before the 1st of August 2023?
No, my lord, we're not aware of this specific photo they pulled to.
And that particular photo was not self-standing. You understand what I mean? It wasn't self-standing like this. And
It's part of a bundle, my lord.
yeah,
Yes.
it wasn't self-standing. And let's just show this video, like so.
Yes.
It was part of the band.
Let me understand the court. The photos that you were provided on a PDF document.
Now that I'm aware of, and then they were downloaded.
Yes.
And then Mabasa says the pigmentation of the photo
Yes.
wasn't bright.
Yes.
That's why you have to use software.
To just add lights.
Listen,
That's correct.
but what's intriguing, if they were not visible to the naked eye after being downloaded from the
SD card.
the device, yeah,
Yes.
they were not visible. This, when I say they were not, this one was not visible.
My lord, it depends. Let me explain to the
Don't run away
court.
from my question.
No, I'm not running away from the court's question. I'm saying, my lord,
Was it visible to the naked eye, or was it not visible to the naked eye?
it was visible on the naked eye when we went through the photos one by one.
Yes.
Yes. If you scroll through the photos,
Yeah.
you won't be able to pick it up.
Yes.
But if you then sit down, take your time, and then you zoom in and out, then you'll be able to pick it up. But if you're going to rush into looking into the photo, then you won't be able to see.
Okay.
And I can also mention, my lord, from the photos that I personally went through of accused number 3, I think that is the only, if not, I'm under correction, my lord. Okay, I just had my colleagues. Let me just type it here, my lord. I wanted to make another submission, but take it up during.
No, maybe.
I'll be accused of testifying, my lord.
I'm still going to maybe ask questions regarding your answers.
I'm saying it's one of the few photos
Yeah.
that one can see the accused person smiling.
Oh.
From the ones that I have seen personally, out of the 700 photos, I cannot recall them, but it's one of them that stood out for me, that particular photo. That's quite possible. And it has to be enhanced, man. That's what I'm saying, it has to be enhanced. And it was not a one-day process. I have to, at some stage, look into the photo and then go home, come back tomorrow, print, look into it, then...
And this is a probable question. Does the accused have the mechanism and the means and the equipment to enhance the photos? I'm not talking about his lawyer. Talking about the accused.
No, the accused does not have it.
And without any technical assistance, you will never get. And I'm speaking like he is not represented. You will never get the photograph to come to this perfection. The expertise.
I'm not sure.
You don't understand it.
I understand what the court, what the court is saying.
Yeah.
Just that I do not know his level of
Now,
understanding.
he's not at the level of an analyst.
But I can also do that, my lord, but I'm not an analyst.
Yeah, but I just want to pierce through.
Yeah, if he can have a laptop and then the photograph, surely he can zoom in and out because the function that is readily available on PDF as well.
If he doesn't have that?
If he does not have that, that's why we prepared that document where it's zoomed in.
Right, and since this 3 years, 3 months before he testifies against a witness who alludes to the existence of this photograph.
Our point of departure, my lord, is the question whether he had a gold tooth or not is something that falls within his personal knowledge. If he sees it and he says, I never had a gold tooth, I think for me that is enough. Then the cross-examination of this witness can proceed, and then it can be put to Mabasa that you edited this photo, you manipulated this photo. I never had a gold tooth. Don't have to go to a dentist to confirm whether you had it or not. It's something that falls within his personal knowledge. And that won't change me.
But what about the fact that this counsel says he never could consult with his client because he says he wants a dentist for the professional to give an opinion.
My lord, by all means, you can go and get an opinion. Yes, but the witness that you are dealing with, the one that is on the stand is Sergeant Mabas, an analyst.
Yeah, fine.
It won't change the fact that accused never had a good tooth. Then that will be a second part of his right to give and to adduce and challenge evidence. Okay. He will have already challenged Mabasa on his findings, and then later on, during his case, he can adduce a report, which is perfectly allowed. But it would be unfair for him to first determine the wind, the direction of the wind, so that he can make up his mind. It would be unfair for the witness, it would be unfair to the state. And furthermore, what is important, the court asked few interesting questions to the other witness, our warrant officer, regarding these observations. To say, do you use spectacles? Are you able to see there? And I think that deals with the issues of observation. And that's what Mabasa is also here to testify about. What Tabang Makeleni saw on the 26th of October is also observation. And it's there. Let's go, please.
Maybe nothing. Mr. Macy, who wants to edge on.
As it is the court, my lord, I'm going to be very short. I do not hear the state talking about that we are misapplying the provisions of section 35(3)(b) when we request that accused should be afforded the opportunity to prepare his defense, my lord. And with regard to enough opportunity and facility to prepare his defense in order to challenge the state's case, the state does not address that. Number two, the state is also missing the aspect of a prejudice. I haven't heard them saying that any other person or any interested party in these proceedings will be prejudiced if accused person were to be afforded this constitutional imperative, my lord, for him to go and prepare his defense and have all the necessary amenities to prepare such. But another point, my lord, that is being raised by the state is that I cross-examined Makeleni and specifically put to him or her, I can't even remember whether it was a woman or a man, that accused number 3 had a golden teeth. I think that it's mistaken. I never cross-examined any witness who was
dead.
Yes. So, but that's what the state is saying. So, but as I'm saying, I never cross-examined a witness who purportedly was called by the state who came to testify about them being around the scene. It is only one witness that I cross-examined, the witness who was seated in the motor vehicle. But those who were in the house and all those who made statement, I'd never cross-examined them. Now, the state is further saying that we're not offering any reason why we're making this application. I don't know what is the thinking of the state and what is the basis of saying that, but let me quickly say that it is not a flimsy request. The state does not dispute the fact that for almost 10 years, the investigating team had these photos. And for almost 5 years, the prosecution team had these photos. And on the date on which the photos were handed over to us, which is in the month of April 2025, the state does not dispute the fact that they never mentioned that the reason why we want to introduce this evidence is specifically because we want to demonstrate that at the time of the commission of the offense, accused number 3 had a golden teeth. They never mentioned that reason, my lord. Had they mentioned that reason, I would have actually made it a point that thenceforth I deal with the aspect for the purpose of the new evidence that is being introduced to demonstrate that accused number 3 had a golden teeth. It is only during the testimony of Mr. Mabaso that, as I've said, we're shell-shocked to learn that accused number 3 had a golden teeth at that time. That was the first time that we came to know the purpose for which the state actually led this evidence for. And for the state to say that it doesn't matter, we can as well put our version even if we have not thoroughly prepared for the evidence of Mr. That goes against the Constitution. Look, I need to be very honest with the state. Our cross-examination is structured. Our cross-examination is found on certain basis. Our cross-examination is just not a one-ton cross-examination, my lord. And there's authority of just missing that case that says that a cross-examiner should be wary of putting information to a witness without verifying the authenticity of that information, because it will be very difficult for the cross-examiner to withdraw that information or that suggestion upon upon them finding out the real nature of things. Mr. Ramusipili indicated that what we are requesting can go either way. It can be in favor of the state, it can be in favor of the accused. So if the accused says, no, I request that I should be given an opportunity to be assessed before I come and cross-examine this. If information comes out and say, no, but accused person, you dug your own grave, then you can go inside it, then let it be so. But the state cannot say, no, the defense must do this even before they are not ready. How can I proceed to put on questions to Mr. Mabaso when I am not ready to do so? And I've indicated to the court, my lord, that that would be a misrepresentation of what I'm sending for here, which I solemnly undertook that I'll do the best that I can to conduct accused number 3's defense in the best possible way that I can, my lord. Now, this in the larger part of what is contained in the defense's heads of argument, my lord, there's nothing that is in dispute between the state and the application that accused number 3 is bringing. All that the state wants, it says, no, Mr. Minister, continue to cross-examine Mr. Mabaso, even if you do not have that information that will enable you to cross-examine him with. But I am saying to the state, I am not in a position to do that because I want this information. And an accused person has got a constitutional right to get that information, my lord. So I've quoted at length the values that are enshrined in the Constitution in terms of what a fair trial is. I've said accused person does not ask something out of the ordinary. He's basing his request on the Constitution. This is a constitutional imperative than a procedural requirement, my Lord. I would therefore submit, my Lord, that in my response, that in the greatest analogy of things, I don't think that state and accused number 3 are far apart from each other, except the fact that the state says, no, you can cross-examine, and I'm saying I'm not ready. And if I'm not ready, I don't want to prejudice accused person's place. I would therefore request, my Lord, that my state of unreadiness was not a self-made state of unreadiness. It's a state of unreadiness that came as a result of what the state did, their failure to disclose to us this information when they already had it for 5 years and 10 years simultaneously. The group that represents the state had this information for 15 years. And Mr. Sibanda says that they had to go for more than 5,700 photos, my Lord. That is not entirely correct, my Lord. Look, we are here on the case of accused number 3. There are 700 photos that they had to go through. 700 photos that they had to go through in respect of accused number 3. And out of those 700 photos, there are photos that are women photos, children photos, church photos, firearm photos, car photos, and all those photos which have got nothing to do with accused number 3's teeth. There are very few photos that are contained in those 700 photos that will denote accused number 3's dental formula. So it's not like the state had to take for more than 5 years only to identify 1, 2, 3, or even 4 photos where accused number 3 dental formula is visible for them to come to a conclusion that as and when he allegedly was part of the commission of the offense, he had a dental formula. I think that is a gross misrepresentation of facts, my Lord. They are just trying very hard to give a reason as to why, up until the testimony of Warrant Officer Mabaso, we were not appraised of the fact that his evidence would be to demonstrate that Warrant Officer Mabaso had a golden tooth at the time. And there's also a misnomer in what the court is being told. It is suggested that through my own eyes, I found information from Brigadier Gininda. Actually, I put to Brigadier Gininda that indeed accused number 3 had golden teeth, had a white alabaster of skin perfection, and had dreadlocks. No, that did not come from me. Brigadier Gininda, when he applied for the warrant of arrest of accused, I think that was in Exhibit J, if I'm not mistaken, he mentioned, amongst others, that the perpetrator, who was a gun-toting perpetrator going to the house, had those features. I was taking him through what he said in his affidavit when he applied for a warrant of arrest, and then I further requested him to say, okay, this is what you told the magistrate. He said yes. Can we then go to Exhibit S and determine these features which you said the gun-toting perpetrator had them? It's not like it is the defense that says accused number 1 had those features. I think that is grossly misquoted, my Lord. But in the larger part of things, I will still stand by our argument that the accused has been able to make up a case that at least he should be accorded to this constitutional imperative, this constitutional right to be allowed to prepare himself for the cross-examination of the evidence that the defense was shocked with when Warrant Officer Mabaso testified. I would request that the court find in his wisdom that he should be afforded that constitutional requirement, my Lord. Thank you, my Lord. That would be my response.
As the court pleases, my Lord. My Lord, just a short one. At paragraph 6.1 of the state's heads of argument.
6.1.
Yes. It reads, Sergeant Babasa is an analyst, and as a result, he must be challenged with the information in the X-ray format, which cannot be tampered with, edited, manipulated in any way. And by his observation, of the photograph of accused number 3 depicting him with a gold tooth, my Lord. My Lord, part of my cross-examination and Ms. Mshololo at the end to Warrant Officer Ndlovu was to get a concession the metadata and especially photographs can be edited, can be manipulated, can be tampered with. He made that concession, my Lord. The last question of Advocate Mshololo. So that is not correct to say this cannot be edited, manipulated, altered in any way. In the height of argument, my Lord. That's the court, please.
Thank you, my Lord. I have nothing further.
I have no submissions.
Yeah, please. Tell me, are we going to wait during recess?
The stage is available.
Are we going to wait during recess?
My Lord, I'll speak for myself. The longer I'm in this case, my practice is collapsing, my Lord. I need to service other clients.
My Lord, I'm already committed in other cases.
So you're not available?
Not
I'm
available.
not available, my Lord.
You say you're not available?
I'm not available, my Lord.
Okay, Mr. Newman.
I am available. I am available.
As it is the court, my Lord, this for obvious reasons, my Lord. Look, I had to start to prepare for the cross-examination on behalf of accused number 1 to Brigadier Kininda, and I had to go voluminous pages. When other colleagues of mine and everybody else had their fair share of rest in the first stanza, when we closed for the first session period, I had to go and read, my Lord. So I have had no time to rest. I am very exhausted, so I don't think I will be available in the recess, my Lord.
You're not available?
No, I will not be available. Yes, my Lord. I need to go and rest.
You are to be in order now, and the reasons will follow. That is say at an appropriate time. I never do that. Deliver the ruling or reasons. Order, without giving an order, but in this case, we have pressed the time. See, we lost 4 weeks already now, because some persons are not available. It's only the state and Mr. Nomad who are available. Okay, so the order I grant is the court finds that accused number 3's counsel has shown on the probabilities that is persuaded this court that there could possibly be an instantaneous refusal or denial of accused number 3's rights as he understands them. We're not dealing with a ballistic expert. He says, it's not persuasive. He says, if it's not represented, him alone, he will never know how to decipher these photographs. Whether to enhance them, etc., etc. So for those reasons, give him the benefit of the doubt that
I'm tripped over the wire. Sorry.
oh, sorry. Yeah, so what the order is, consent is accorded to accused number 3 and this consent, the consult, as they say, what, a dentist or what? A dentist or a dental practitioner of their choice. Right. So the next thing now is, when will the examination by the dentist take place?
As it please the court, my lord. Basically, we're not saying exclusively by a dentist of his own choice. Remember, accused number...
That's his own choice. You said that, I was listening to you. Now, I think you're saying the state must do it. That changes the dynamics. Because you are listening to the argument of the state. They say the client has got the right or the constitutional right to do it after you have conducted the cross-examination.
It is fine, my lord. I will have to take it up with the...
No, you can apply for legal aid if your client is not having the financial means to do that.
Yes, my lord. But on the same breath, I'll have to take it up with the correctional services who are responsible for his custody and arrange with them those dynamics, my lord. I can only hope that they cooperate, because if they don't cooperate, then that is going to further delay this process. Because I may just mention that as early as Friday, I had already started to talk to them. I wrote to the legal advisor, one of the ladies who was here, when we were applying for, or when we were arranging the process to apply for the challenge that he had with his incarceration in solitary confinement. I haven't had a response. At lunchtime, I asked her what the developments are. She said to me she has not received anything from the superiors there at correctional services, but she will follow. So my intuition is telling me I might be met with a bit of a resistance, but let me put on record that resistance, wherever they are, if they are listening or if they are able to hear, or members of the correctional services are here, and one is responsible for accused number 3, that resistance will not be in the interest of administration of justice, because I am saying, my lord, that my intuition is telling me that possibly I could be met with a resistance in being assisted to have accused person referred for a dental assessment by an independent orthodontist or a dentist, my lord.
Okay, let's take this through so that it makes sense.
Yes, my lord.
Mr. Dr. Van, will the state pay for this? Will it be willing to pay? Because this is the first time in
It's for the first time, my lord. It's for the first time. I mean, with the state, there are state dentists that you can use, but if you want to use his own, then you have to pay.
There have been 2 cases like this, where I paid out of my own pocket. That case was in 15 years back. The accused person started writhing, as if he's eaten poisonous food or whatever. We adjourned. I said he must phone the district surgeon. They phoned the district surgeons at the time. There were only 2 district surgeons available in Johannesburg. They told us that these gentlemen are out of town on a particular errand. Then I spoke to the prosecutor. Can we take this gentleman to Carlton Center, because I knew that there's a physician there too. Then your colleague then told me, no, you need 3 quotations. You must submit 3 quotations, and then you take the department to take the least expensive quotation to pay. How long will that take? As we don't know, and the guy, I didn't know, the rest is dying. So I phoned this gentleman, who's a physician, to come to court and attend to this gentleman who was writhing on the floor, being sick or ill and vomiting. They attended to that exigency, and I paid out of my own pocket. Then I got flat, as I usually do. Hey, the way you want to convict our clients, we have appeals to bicycle the hotel. I never paid that money there because the regulations don't make provision for it. So let's be clear. How are you going to finance it?
My lord, I think on the last appearance,
No, I want the state first to tell us, because your client is available to you.
my lord, the state can assist him with the state dentist.
State,
Dentist, the one that works for the state.
are you prepared that the state dentist? That's what we said. You won't fabricate things.
I'm the last one to say that, my lord,
I've
because
been listening to fabrication all along. Telephone numbers were fabricated, fingerprints and those fingerprints. What do you call it?
probably the DNA results as
Cell
well.
phone numbers were fabricated, etc., etc.
Yes, ma'am. As I'm saying, my lord, I'll be the very last one to say that because I know Mr. Mncube, as of now, is in the care and custody of the state. So the first point of reference when issues of this nature arise is for him to refer to a district surgeon.
Okay, fine.
It is only in extremely extraordinary circumstances where he can be taken out of the perimeters of those who are holding him and be referred to a private practitioner.
However, we can make an order. So,
Thank you, madam.
so there's no problem if the district surgeon who feels a J88 attends to the client.
I definitely have no problem, my lord, but it should be a surgeon who has got a particular expertise on the field of teeth.
I will let you.
I think there are dentists who are also working for the state, my lord, who work with the district surgeon. Remember, a district surgeon is just an institution. There are pediatric pediatricians there. There are oncologists there.
Yes, you're
there are
right.
orthodontists there. There's everyone, my
You're
lord.
right.
Yes.
The district surgeon there, if he sees that you need an amputation,
Yes.
you recommend the surgeon.
Yes, my lord. Yes.
Physician,
Yes.
orthodontist or
Yes.
whatever.
Yes. But then the first point of reference would then be a district surgeon.
Wait. Everyone has problems.
Yes, my lord.
So you're trying to make use of state facilities because here you said to me you're trying one for the state, one practitioner who's employed by the state, and another one apparently who's in a private practice.
Let me clarify the position with him, my lord, because I don't want to speak on his behalf.
Yeah,
I can
find out.
only carry out instructions, my lord.
Eseza kwenu baba Mnisi, inkundla ivumile mfethu ukuthi ke uhambe uyobona nodokotela manje umbuzo ukuthi ke uzosebenzisa umbuso noma ofunwa uwena.
It's a matter of interest. I don't know if you remember the stages. I listened to evidence in this court. Somebody saying, it's my brother who has a tooth, a golden tooth, and not my other brother. You remember the stages?
I remember my lord.
If you can follow it, you get the name of the other brother who's got a golden tooth. And he may be able to tell you where you can eat this other brother can find solace.
Yeah, I recall the evidence, my lord. It was during the cross-examination of Brigadier Gininda as well.
Yeah.
The name of the brother is Kwazinkosi or something.
Yeah, tell us it with Mr. Nisi. Because apparently there's another brother. Let me just say another. There's a brother who has a golden tooth.
As it pleases the court, my lord, for indulgence, I think Mr. Mncube is being brutally honest here. he says, on account of the fact that there are so many things that have happened in this trial, he has totally lost confidence in the state machineries. So he would prefer that the court makes a directive that he be seen by a private practitioner who's got knowledge on dental formulas. That is what is coming from here.
Kuthi-ke impendulo ebuya kuwena Mr. Mncube ukuthi nje uzokhuluma-ke iqiniso la ukuthi-ke ngokungathembi kwakho-ke umbuso usucela inkantolo ukuthi-ke ikhiphe-ke isinqumo sokuthi wena uhambe uyoyibonela nje udokotela-ke oyimele, awufuni-ke ukuthi uyobona ongaphansi kombuso.
I suggest, my lord, that we may adjourn for now and then come back tomorrow. I think I would have a clue, because another thing he's asking me as to how much would be the cost implications be, and I'm saying to him, I never had dental problems. My teeth are still, I think they're 38 or 35 in my mouth. I never had that problem. So I specifically don't have a clue as to how much the cost implications will be. But if we can adjourn up until tomorrow, I think when I come back, I would be having a bit of information as to the amount at which the private practitioner would cost.
So he doesn't want a state practitioner?
He says, on account of the fact... Yes.
He doesn't want a state practitioner.
He says, my lord, he's very cautious. He's very cautious.
Is it possible, Mr. Badoy, I want to find out. If tomorrow you can report.
Let's go this minute. We left to inquire and report back to us. On Thursday, because this amendment will
yeah, but then, yeah, because of the problem of the other cancer is not available. It means, yeah, during this week, we have to fix something concrete. And then we will postpone. The witness should be available so that we can continue with that.
But we can reconvene on Thursday with the feedback.
Is that okay? Thursday?
It is in order, my lord.
It's in order, my lord.
Okay. Come back on Thursday.
Sasa ngalazo ngolosine lapho thola khona-ke impendulo.
Thanks for watching.